The Companies Act 1956. Today, let us focus our attention on Section 36 of the Companies Act 1956. Section 36 says effect of memorandum when, and it also says effect of articles. Both these documents, first Memorandum of Association, second document Articles of Associations. Section 36 is saying as effect of Memorandum of Association document and also what is the effect of Articles of Association. So is it before incorporation or after incorporation? The effect Memorandum of Association shall have effect only after incorporation. Similarly, Articles of Association also will have an effect only after incorporation or getting registered. You may recollect Section 34. Section 34 was enabling us to understand the effect of registration. What was it telling us? What was it about registration of a company? When we approach for registration to the registrar along with documents like Memorandum of Association, Articles of Association, and if there is any agreement which the company proposes to enter into with any individual for appointment as its managing or whole-time director or manager. With these three documents, again let us remind what are these three documents. First, Memorandum of Association. Second, Articles of Association. Third one, if it is there, an agreement. With these three documents, a company approaches the registrar for registration. The registrar of the state in which the registered office of the company is stated by the memorandum shall register. On receipt of a declaration that you are aware, the declaration is expected to be given by three categories of persons. It may be an advocate of the Supreme Court or a High Court, an attorney or a pleader entitled to appear before a High Court. Second category, a declaration may also be given by a secretary, that is company secretary or a chartered accountant in whole-time practice who is engaged in the formation of a company. Similarly, a declaration may also be given by a person named in the articles as a director or as a manager or secretary of the company. That what does this declaration carry? What information does it provide? Declaration says that all the requirements of this act, underline all the requirements of this act and also the rules thereunder have been complied with in respect of registration and matters precedent and incidental thereto. So this declaration carries this message to the registrar. Let us try to understand again. Let us reread it. What declaration carries? Declaration gives a message, a declaration that all the requirements of this act, all the requirements of this act and the rules thereunder have been complied with in respect of the registration and matters precedent and incidental thereto. With this declaration, the registrar gets satisfied that a declaration has sufficient evidence of such compliance. So, on receipt of this declaration, the registrar may get satisfied that as sufficient evidence of such compliance on receipt of this declaration. So, if the registrar is satisfied, what is he going to do? He will retain copies of the Memorandum of Association. copy of Articles of Association and says that the company is authorized to get registered. On registration, we were learning in section 34 what is the effect of registration. The effect of registration is that on registration, registrar will certify under his hand that the company is incorporated. What is he going to do? The registrar? The registrar will certify under his hand that the company is incorporated. And he shall also do, in the case of a limited company, that he will certify that the company is also a limited. Both statements he may issue. The second statement may issue depending upon the case. If the company is a limited, registrar will certify that the company is limited. Otherwise, he may just say that company is incorporated under his hand by certifying it. So now we were also understanding in section 34 another point that, sorry, section 35. In section 35, the provisions were explaining us that the certificate of incorporation issued by the registrar on registration is a conclusive evidence. Let us read it. What the provisions of section 35 say. A certificate of incorporation, underline, a certificate of incorporation given by the registrar in respect of any association shall be conclusive evidence. Again, a certificate of incorporation given by the registrar in respect of any association shall be conclusive evidence of what? That all the requirements of this act have been complied with in respect of registration and matters precedent and incidental thereto, and to the association, that the association is a company authorized to be registered and duly registered under this act. So like this, on registration by the registrar, company gets certificate of incorporation. The certificate of incorporation, as far as section 35 of the Companies Act 1956 goes, that it is a conclusive evidence that the company is registered or incorporated, and it is also a conclusive evidence that all the requirements of this act have been complied with in respect of registration on matters precedent and incidental thereto. Now let us try to understand what would be the effect of registration on both documents. Both documents means here first one is Memorandum of Association and second one is Articles of Association. On registration, after getting certificate of incorporation, which was a conclusive evidence that all the requirements of registration are complied with. Now let us revisit our subject, section 36 of the Companies Act 1956. What would be the effect? Subject to the provisions of this act, subsection 1 of section 36. Subject to the provisions of this act, the Memorandum of Association and Articles of Association both shall bind the company when on registration. On registration, subject to the provisions of this act, the Memorandum of Association and Articles of Association. Underline, on registration, subject to the provisions of this act, the Memorandum of Association and Articles of Association both shall bind the company. Both shall bind the company and the members thereof to the same extent. So on registration, both documents shall bind the company and also the members thereof to the same extent as if they respectively had been signed by the company and by each member, and contain covenants on its and is part to observe all the provisions of the memorandum and of the articles. So in section 36, we are able to understand on registration, the Memorandum of Association or Articles of Association will become effective. Both will bind the company and also the members thereof to the same extent. Let us go to subsection 2 of section 36. All money payable by any member to the company, again, all money payable by any member to the company under the memorandum or articles shall be a debt due from him to the company. So before incorporation, the subscribers to the memorandum are not liable to pay. This is what we will come to conclusion, that are not liable to pay to the company. So once it gets incorporated, the effect of incorporation will carried by the memorandum of association and articles of association. Once it gets incorporated, all money payable by any member to the company under the memorandum or articles shall be a debt due from him to the company. So from section 36 of the Companies Act 1956, it is clear for us. Let us read it. Subsection 1 of section 36. Subject to the memorandum, subject to the provisions of this act, underlined before this, we need to understand, on registration, subject to the provisions of this act, the memorandum of association and the articles of association both shall bind the company and the members thereof to the same extent, as if they respectively had been signed by the company and by each member, and contained covenants on its and is part to observe all the provisions of the memorandum and of the articles. Subsection 2 of section 36 says as, all money payable by any member to the company, all money payable by any member to the company under the memorandum of association or articles of association shall be a debt due from him to the company.